The Madlanga Commission of Inquiry heard fresh testimony today that lays bare the extent of political meddling in prosecutorial decisions. Former senior National Prosecuting Authority officials described repeated attempts by politicians and their proxies to dictate which cases advanced and which were buried. The evidence points directly at breaches of Section 179 of the Constitution, which demands that the NPA exercise its functions without fear, favor, or prejudice. One witness detailed how instructions arrived via back channels from Luthuli House and ministerial offices, pressuring prosecutors to drop or fast-track matters involving connected individuals. These were not vague suggestions. They came with threats of transfers, blocked promotions, and even fabricated disciplinary action. The pattern matches earlier evidence from the Zondo Commission. Yet it continues to surface because the structural weaknesses remain unaddressed. Constitutionally, this matters. The rule of law requires that the executive and legislature stay out of the charging process. Once that line is crossed, the NPA ceases to be an independent constitutional body and becomes an instrument of political power. Witnesses today confirmed that such interference distorted case selection in high-profile corruption and organized crime matters. Some dockets simply vanished from the system for months. Others were returned with handwritten annotations demanding further investigation that amounted to stalling tactics. The implications stretch beyond individual prosecutions. Public confidence in the criminal justice system rests on the perception that outcomes are determined by evidence, not proximity to power. When testimony shows that senior prosecutors felt compelled to seek political clearance before proceeding against certain accused, the separation of powers collapses in practice, even if it survives on paper. Courts can only adjudicate the cases that reach them. If gatekeepers are compromised upstream, judicial independence offers limited protection. The Commission also received documents showing internal NPA memoranda warning against certain investigations because of expected political pushback. These notes were not isolated. They formed part of a culture where career survival depended on reading the political wind. Such behavior violates the oath taken by prosecutors to uphold the Constitution. It also exposes the state to successful review applications on grounds of irrationality and bad faith. Fairness requires noting that not every allegation has been tested under cross-examination. Some witnesses carry their own baggage from the state capture years. Yet the consistency across multiple accounts, supported by contemporaneous records, makes blanket dismissal difficult. The Commission's mandate is to establish facts, not to secure convictions. Its findings will likely feed into recommendations for legislative and institutional reform. What stands out is the absence of meaningful pushback from within the system at the time. Few officials appear to have escalated these pressures to the courts or to Parliament's Justice Committee. That silence itself weakens the rule of law. Institutions defend themselves through their members' willingness to resist unlawful instructions. Where that willingness is missing, constitutional safeguards become ornamental. Today's evidence therefore does more than recount past abuses. It tests whether South Africa has the institutional will to restore prosecutorial independence. Without concrete steps, clearer statutory protections against removal, independent vetting of senior appointments, and real sanctions for interference, the testimony will join the growing archive of inquiries whose recommendations gather dust. The Constitution provides the framework. What remains is the political courage to enforce it.